Um, the when you're looking at a contract, I mean, one of the reasons people have lawyers look at the contract is the the fine print, the technical language, the way things are phrased. All those details are important. They all matter, and they can affect what your contractual rights are. The old phrase, "The devil is in the details," is never so true as when you're talking about contracts. And so we want to take apart the typical superintendent contract into its component parts and look at that and ask ourselves whether we're considering each component part of the contract carefully. Uh, when I talk about contracts with, particularly with new superintendents, um, one of the things I want people to understand is a contract defines a relationship. And when that superintendent is hired for the first time by a school board, it's kind of like a marriage. You are entering into a relationship with people that you're going to be spending a lot of time with. You're going to be potentially in conflict with. You're going to have a shared mission with. There are a lot of things about the superintendency as it relates to the school board that sort of track the way a marriage relationship works. And as many people these days go into marriages with prenuptial agreements defining what they will have if the marriage is over at some point, and we know that 50% or more marriages end in divorce, so it's very, very common. And so think of your contract in some ways as a prenup agreement that will be helpful to you uh, if and when things go south. Now, what often there's a cycle to these things that I've seen over and over again as I've done this over the years. That when a new superintendent goes in with a school board that hired them and they have a shared mission and shared values and everybody gets along great, the relationship bears fruit and it prospers, much as a young family grows and does well, and everybody's kind of doing their thing and it's going great. And you wish that would last forever, but the reality is it often doesn't. What happens is tension starts to come in, conflict arises. You may have new board members. You may have board members that ran for election on a platform of getting rid of the superintendent. And anybody on this call that's an experienced superintendent could probably tell us war stories about how elections completely changed their lives, and how board members came in who were hostile and difficult. And so when you enter into a contract as a superintendent, you have to realize that the spouse could change. It could be a different person. That's where it really does change, because the board that hired you really liked you, but that doesn't mean that the board that you inherit after an election really likes you, and you have to be realistic about that. And not only may they not really like you, they may not like you at all, and they may want you out of there. Um, so that's when you get to the divorce. That's when you get to the termination, and then you say, all right, what's going to happen now? Um, I, I've put my heart and soul, my life into this job, and now I'm leaving it. That is a difficult time, and I have had difficult conversations with school superintendents about that, because it really does rock your world. Uh, and when they refer to lawyers as counselors, sometimes people will say counselor. There really is a counseling aspect to what I do, because just getting people through this process is sometimes very difficult for them, and they need perspective. And so we want to make sure that we have as much perspective early as possible, so that we're not so surprised when the inevitable occurs. So the contract is the protection. The contract is the front end of the relationship. It defines your compensation. It it defines and protects your health insurance and your other benefits. It defines and protects you against later claims or suits. We're going to talk about the indemnity clause of your contract. And none of these things is guaranteed unless you have a contract that guarantees them, because the board, when it terminates you, is going to want to minimize what you get. And you're in a much stronger position if you can if you can say to the board chair, which is typically who you're negotiating with, that look, all of this has been prearranged. We all saw this day coming. We knew it would happen. And we already know what's going to happen when the day comes. So let's just follow the contract. So the first question is the term. How long does the contract last? Well, in this case, it's defined by Virginia law, which makes it a lot simpler. Virginia law states that the initial contract shall be for no less than 2 years and no more than 4 years, and it has to end on June 30. Now, that's important because let's say you enter into a contract in November or December, all right? And the board wants to give you a 4-year contract, but they can't give you a 4-year contract because it has to end on June 30. So all they can give you is the 3 years and the number of months that would run until June 30. So if it were November, it would be 3 years and 11 months. I mean, 3 years and 7 months. Now, when you do a renewal contract, when you get to the end of that first initial contract and you want to do a new contract, the new contract could be for as little as 1 year and then up to 4 years, and it still has the same June 30 term end date. So sometimes you'll see situations where the board is starting to question whether they have the right superintendent, and they want some transition time or some observation time, and so they ask for a 1-year contract. I tend to push pretty hard to get at least 2 on these renewals, and of course, what I'm always counseling people to do, if possible, is get 4. And because the longer your term, the longer your protection, and the greater is the commitment. But as we're going to talk about later, what really matters is the severance clause, which we'll get to. But the initial contract of 2 to 4 years, because it's a new contract and because many times it's a new superintendent who's never been a superintendent, you've never had the opportunity to prove yourself in the position, the board may not offer you 4 years up front. They may want to take a look at you. And they may say, well, gosh, let's do a 2-year contract. But then you're thinking, well, I'm being asked to move my family, to relocate, to sell my house. I've got a lot invested in this. I really wanted a 4-year contract. And so you sort of compromise on a 3-year contract. That's not bad. There's nothing wrong with a 3-year contract. That gives you a pretty good long runway to build a relationship with the board. But while you're on that runway, when you see that things are going well, let's say you get 2 years into the contract. Let's say you're in the spring of the 2nd year and you're coming up, right now, April, May, June, you're coming up toward the end of that 2nd year. You still have another year to go. That's a great time to renegotiate a new 4-year agreement, rather than waiting until the end of that 3rd year, running the risk that something will happen. I think anytime you have a contract, you want to try to renegotiate it for an additional 4 years, whenever you're getting near the point in time where you've got about a year left. Now, we used to write the contracts with what I would refer to as an automatic extension. So the contracts would say that the school board has to give the superintendent notice of non-renewal, and if the school board doesn't give the superintendent notice for non-renewal by some date like March 31st, then the contract will roll over for a new 4-year contract starting on July 1. So what that gave you was what you call a rolling 4-year contract. And I guess that was too successful because the General Assembly, under pressure from the school, from the School Board Association, changed that to say that you can't do, that the contract can't run more than 4 years. So when they say it can't run more than 4 years, a rolling contract or an automatic extension contract causes the contract to run more than 4 years. So we can't build those in anymore. So what you have to do is just do it de facto through negotiation. So, what's the takeaway? You want the longest contract possible, but it's not always possible to have a 4-year contract. And so just think about how to maximize the term of your contract as best you can. Compensation, how much you're paid is really important. It's why you work in many ways. And so what are the components of that? And what are the factors you want to consider? Well, the most important term, excuse me, is base salary. And you may want to consider in your base salary, when you define your base salary, having what's called an automatic escalator. An automatic escalator would be something like a clause that says that you get the average increase awarded to professional employees. So if your teachers get a 3% raise, you get a 3% raise. Excuse me just a second. Sorry, it is spring and allergy time. I've seen automatic escalators that are just a percentage, that you get a 3% increase every year or a 4% increase every year, something like that. But nevertheless, having automatic escalators is good. I like having the automatic escalator tied to what the increase that teachers get, because then your increase doesn't become a political issue. You're actually tying your compensation to your teachers, which I think allows a really good message that we're all in this together. Whereas if you do it like an automatic increase by percentage, then every year you get an increase, but the teachers may not get an increase, or they may not get as big an increase. And then you become the issue. Why are you getting so much money when the teachers aren't? You're already the highest paid employee in the school district. And so you want to avoid these political message problems, particularly as the General Assembly moves us closer and closer to having teacher unions, which is another conversation for another day. But if school boards start doing that, your life is going to change radically, and everything about your contract is going to become an issue at bargaining, because the teachers are going to want everything that the superintendent has. Deferred compensation is important. It's a way to get additional money without stating your base salary as being too high. So let's say you're in a situation where your base salary is $150,000 a year, and you're getting paid right at the same number as the county administrator, but your school board really likes you and they would like to pay you more money. But if they pay you more money, then that's going to be an issue with the Board of Supervisors. It's going to be an issue with the public. The media is going to run your salary in the paper. You don't want your base salary to be so high that it becomes an issue. So a great way to do that is with deferred comp, which is another line item. It's permitted by VRS, and so you can use deferred comp for an annuity or contributions to a 403B plan. There are limitations on how much that can be, but it could be pretty significant. And so that is money that could take you from, say, 150,000 to 170,000. That extra 20,000 is not taxed until you take the money out years from now, presumably at a lower tax rate. And so you're actually increasing your compensation by a lot without increasing your tax liability or your political liability. And so it's a pretty good thing to think about. And then another thing that we're doing increasingly is superintendents often get fairly good annual leave. They get good sick leave. It accumulates over time. It's hard for superintendent to even use all their annual leave because you have jobs that keep you very busy all the time. I see pretty substantial annual leave banks build up. And so what do you do with that accrual of leave? One of the things that I think is a great thing to do is to have some annual leave or even some sick leave bought back at the end of each contract year, which can be either paid out as straight salary, which would be taxable, but it's not VRS comp, because they're paying for a benefit, not for salary, but it would still, from a tax perspective, be taxable. Or roll that amount into your 403b or your annuity, so that it's done on a tax exempt basis, and it enhances that annuity or 403b plan if you're not already up against the max. So doing an annual buyback is great. You can do, and I often see, an end of the contract buyback of any annual or sick leave. Uh, the problem with that, and I think it's great, so I'm not saying don't do it, but be aware of this. That number is going to be a big number. It's going to build up and build up until it's a large number. And if you don't make it to the end of the contract and there's an early termination, and you're still arguing that you're entitled to that money, you don't want that to be a big nut that is hard to crack. And so I like the annual buyback approach because it keeps the number smaller. It happens over a 4-year period instead of all at once, and so it's less likely to create sticker shock. And then again, it can be paid as cash, or it could be added to your deferred comp. Either one is fine. What about benefits? There are lots of benefits that can be negotiated, or some are pretty standard. You're going to get them just by virtue of being an employee, but you're not necessarily limited to the same benefit that other employees have. So your school board may pay for the individual health insurance premium, and then if the teacher or other employee wants to add their spouse or their family or their children to their plan, they pay the additional amount to do that. With superintendent contracts, I would say more than half across the state have the school board paying the full insurance premium for health insurance, regardless of what level the superintendent is choosing. And because that's pre-tax, and because that is and because health insurance has become so expensive, that can be a really great benefit. And so now you will hear it said occasionally, not much anymore, that because of the Affordable Care Act, what's referred to generically as Obamacare, it actually said that you couldn't pay highly compensated employees greater premium amounts than you paid regular employees, and highly compensated was defined as the top 10%. But the IRS has never enforced that, and they specifically suspended that. And so the reality is it's fine, and there's no prohibition on doing that. Now you have life insurance, dental insurance, vision insurance, disability insurance. A lot of those are standard insurances that are offered by your school board. But there are a couple of things on that list that I would say you could pay a little extra attention to. You might want to ask for additional life insurance. The school board could actually pay for a whole life insurance policy for you, which means you would get the cash benefit of that. So a $250,000 whole life policy would actually build up cash value over the time that you are there, and then when you leave, you take the policy with you. So there are benefits to that. Again, and it also keeps that you're accruing money, but you're accruing it outside your base salary. Another thing I've seen done, particularly as people get older, or if they have any underlying health conditions, is ask for supplemental disability insurance. So your basic disability plan might cover 2/3 of your salary for the period of time that you're disabled, which would often go up to your normal retirement age. But if you go from making $150,000 to making $100,000, and you're disabled, so you can't make any more money, that's it. That's going to be a shock to your lifestyle, particularly if that's got to go on for 10 years. A supplemental disability plan will fill that gap. It'll pick up at the 2/3 and take you up to, it can take you up to 80%, it can take you up to 90%, it can take you up to 100%. It's just, the difference is just the premium that you pay. And so having your school board purchase for you supplemental disability insurance would be a way of giving yourself better protection. And so, if you're young and in really good health, and you don't think and you want to put that money in some other bucket, that's fine. But if you're getting to a point where you're starting to be a little concerned about your health, then this is a great way to protect you and your family against any kind of a salary diminution during your final work life years. Um, we often see a car. It can be a car allowance. It can be either one. I've always liked having the car allowance. It used to be that VRS would count that toward creditable comp. That it's clear now that they won't. But the big thing to me is that you're driving your own car. And if you stop at the grocery store or the ABC store or take your kids to soccer practice or whatever, nobody's going to say, oh, the superintendent's using the county car to drive all over the place at our expense. You're trying to avoid, again, political controversies, and a car allowance does that. Now, if your board says, look, we just would rather give you a car, it's the school system car, and you can use it for whatever purpose, that's fine. Just expect there to be more controversy that could arise out of that. Technology is important. You're probably going to want a laptop. You're probably going to want some people like iPads. Everybody needs a cell phone, and they need a smartphone. They need one that does everything. And then the service plans for that technology can be, an expense. And so putting into the contract what technology the board will provide to you, and that the board will pay the service plan on that technology is really prudent. You want to define what your annual leave is. You want to define what your sick leave is. Reimbursements uh, for travel and things like that. You want to make sure that there's a reimbursement statement in there. And then finally, memberships. Pretty much everybody covers the superintendent's cost of membership in the Virginia Association of School Superintendents, which is great. And you want that membership to be paid for by your board. It's for their benefit as much as yours. But often I'll see that, particularly in smaller communities where the superintendent is expected to belong to a club or a service organization, Rotary or something like that. And so if there's an expectation that you would engage in some kind of community activity, the board should pay for that. And that should be built into your contract. Now, there are some other benefits that are what I would call customized. You're asking for them because of your unique circumstances. These would not be within the norm, but just because they're not within the norm doesn't mean you can't ask for them. So some people are still finishing their doctoral degree, and they may want time off to finish those courses. Or reimbursement for those courses. And so asking for that is fine. Maybe you're earning consulting or writing or speaking revenue, and you want to continue to be able to do that. You want to build that into your contract, and I'll talk about that a little more in a minute. And then I've seen people write in that they would have sabbatical or extended leave after some period of time. One of the customized benefits that I saw several years ago that I thought was great was a superintendent in Northern Virginia loved hiking the Appalachian Trail, and he wanted to hike the whole trail. And but he not sort of take the 6 months off and do it, but he thought, well, if I take off a month and do it for 6 years, I can hike the whole trail a month at a time. And he actually wrote into his contract that he would have off the month of July every year to do that, and that he would really have it off. He wouldn't, because he's going to be on the trail. He knew he wouldn't have a cell phone or be checking his email. So the board agreed that for that month he would disconnect, and the associate superintendent would be the acting superintendent during that period of time. They loved the superintendent. They wanted to keep him. They gave him this benefit, and he stayed with them for a long time. So you may have something that you really want to do. And if your board really wants to keep you, they may be incentivized to provide that, whatever that is, for you. So you can be a little creative, thinking about lifestyle issues and health issues and other types of issues that are important to you. Burnout occurs often because you never get away from the job. And building something in your contract that allows you to get away from the job may be what you need to stay in the job longer. What's called a statement of authority. That is, what is it that you control? What are you able to do as superintendent? I think it's wise to have in your contract that you have the ability to assign administrators to their positions. Now, most boards will say with board approval, but nevertheless, you want as much authority in that area as possible. Um, you particularly want the ability to build your own leadership team. Who is going to be the assistant superintendent for finance? Who's going to be the assistant superintendent for instruction? Who's going to be the director of human resources? These are important decisions because they will all be doing things that are going to reflect on you as the superintendent. So the standard language in the VSBA contract, which is fine, it says the superintendent shall have charge of the administration of the school district under the direction of the board. She shall be the chief executive officer for the board, shall select, organize, and assign all personnel as best serves the ABC County Public Schools. All right, it's that the power to select, organize, and assign personnel is a broad and useful power. And then this language is in the standard VSBA contract, and most of you are working off this template. And so I always look for this. The board, both individually and collectively, will promptly refer all criticisms, complaints, and suggestions concerning the schools or its employees to the superintendent for investigation, study, review, and recommendation, right? So you're protecting your power, and you're making sure that the board is bringing things to you and not the board trying to run these things themselves. And I have seen boards take that provision out of the form contract. They delete it when they give the superintendent the contract. And I always put it back in again when I review a contract. I said, don't let them get out of this. This is part of the balance between the things that you're supposed to do and the things that they're supposed to do. And if they're not going to agree to a good and fair and balanced communications protocol between you and the board, if they're not going to agree to a protocol, then this relationship's not going to work, because they're already trying to say we want more power and authority than we are legally entitled to, and we're not going to make that promise. If they won't make that promise, you're in a bad situation. This is something you all need to be aware of. This is important. This could cost you your job. It's a little thing that has huge implications. There is language in the Virginia Code that states that if you accept other employment while you're employed as a superintendent, you have legally abandoned the position of superintendent. Now, while you think of that as, well, I took another job of some substance, there is no limitation on what that other employment is. It's any other employment, not employment of over $10,000 or 20,000 or 100,000. It just says employment. And so it could apply to paid consulting or speaking engagements or teaching that you're doing. It could apply to in anything that you're doing for which you're compensated. So the thing that you want to do is, and a lot of times it says, that you could do these things with board approval, but getting board approval every time you're going to do a consulting gig for which you might get paid $1,000 is just cumbersome. It's not that they wouldn't do it. It's just cumbersome to have to justify it to the whole board. So if you put in the contract that the board chair can approve it on behalf of the board, and then you get that approval, that's a good way to protect yourself and keep it simple, which is always important, I think. And then if there's already something you're going to do because you're doing it and you're coming, like maybe you're teaching an education course on school law or school administration or personnel or something for Virginia Tech or William & Mary or UVA, and you want to keep doing that and you like doing that, to put that into the contract. In that section that talks about other employment, it's in the standard contract. In that section, put in there that teaching a course for Virginia Tech is excluded from this provision. And it could be anything like that, but give yourself some wiggle room so that you're not putting your job at risk if they're just looking for a way to terminate you for cause. Evaluation is important. The standard language it tracks the Virginia code. I think it's a little awkward in actuality, but here's what it says: that there has to be a mutually agreed upon instrument to evaluate the superintendent. All right, that's fine. And in fact, I think the superintendent should present to the board what the superintendent thinks that instrument should be, and then have the board agree. We always say, if you have the chance to do the first draft of something, take it. Using the instrument, the board will evaluate the superintendent annually. All right, that's great. The evaluation must be completed at least 6 months before the end of the fiscal year. That never made any sense to me. What good is an evaluation in December when you're in the middle of a school year? To me, the evaluation should occur in the sort of the May-June period. But nevertheless, this is what the standard language is. It's what the code says. And so you need to do it. So really, it should be a look back to the prior year more than the existing year. And then it should be set aside in a scheduled board meeting to do that. And you should make that just a part of your rotation of topics that you're always going to discuss, just like you do the budget. And then you want to make sure that the language, that all aspects of the discussions will be treated confidentially by the school board and the superintendent, because you don't want board members leaking those discussions to the media. And we know that will happen. It has happened, but you want protection against that. If the board does it, the board's in breach of your contract, and then that gives you some power that you wouldn't have otherwise. Termination. We don't want to talk about termination, but the reality is it happens more often than it doesn't. I'm constantly dealing with termination situations. So we've got to understand what the rules are about termination. In your contract, there are going to be a number of subsections under the termination provision. It's going to talk about termination without cause. It's going to talk about termination by resignation, by retirement, by because of disability. You can be terminated just because you reach the end of your term. It's just you had a 4-year contract, 4 years is up, you're done. Termination for cause is the one that you'd least want to ever be involved in. And then what happens under those different termination provisions is different. So you've got to understand that not all terminations are created equal. So let's take each one, because each one is important. Termination without cause. If you're terminated without cause, that means the board just, for whatever reason, it could be completely whimsical. Probably it's because of an election and you've got new board members. They just decide they want a different superintendent. They want to move on. It's not that you've done anything terrible. It's just that you're not their person anymore. And so they want to terminate you without cause. So you had a 4-year contract. Well, let's take this example. You had an initial 3-year contract, and then the board, in the second year, gives you a new 4-year contract. So now you've got 6 years that you're thinking you're going to have with the school district. You've gotten past the initial term. Things are going great. Then there's an election, and 3 of your 5 board members are replaced. And those board members want to have a new superintendent. It's November of the first year of your 4-year contract. They take office on January 1. On January 2, they decide that they want to terminate you for cause. So your 4-year contract without cause, your 4-year contract just got blown up. And so what's going to happen to your 4-year contract? It's going to be terminated by the board because they have the power to terminate it. So this is where you really have to think on the front end, what are you going to need when that day comes? Now, in the standard VSBA contract, when they send that out to the boards, it has in there that they will pay you 6 months severance. There are very, very few contracts that I see that actually use that 6 month severance. Boards are much more accustomed to paying 1 year salary as severance. And that's what I always push for, is that 1 year. So if you send me your contract to review and I see 6 months, I'm going to say to you, talk to your board about making that a year. And here's the problem. Let's say that that you get to September or November, and the board decides it wants to terminate you without cause, and they terminate your employment. All right, when are you going to have the opportunity to to get another contract? July 1 of the following year. All right, July 1 of the following year is 9 or 10 months from now. All right, 9 or 10 months from now, and you're getting 6 months of salary and benefits. That means you're going to have a salary gap of 3 or 4 months where you're going to be paid nothing. You're going to be just zero compensation if all you had was a 6-month severance pay provision in your contract. So I really like to see everybody have 1 year salary. And that way you're always covered for at least one full cycle. They could terminate you on July the 2nd and you'd be fine until the following July the 1st. And so to me, that's where you want to be. Just recognizing that this, quite frankly, could be your only income for a long time to come. Now, I do see contracts that where the superintendent asks for 1.5 years or asks for 2 years or asks for the, whatever's remaining on the contract, which could be 3.5 years. That's fine if you want to ask for that. I don't tell people don't do it, but what I do advise people is, in my experience, if it's too expensive to buy out the superintendent, then what is the board going to do? The board still wants you gone. So the board is going to try to come up with something that is for cause, because under the standard contract, if they terminate you for cause, they pay you nothing. So why would you want to give an incentive to a board to pay you nothing when you could get a full year? Just, you've got to be smart about that and not overreach. Now, if you ask for 2 years, and particularly if you're in a district that's in pretty good financial shape, you might be able to get that. And maybe that would be a deterrence against the board terminating you, at least in the first couple of years. It'll always say 2 years or whatever's remaining on the contract, whichever is less. So if you're in the last year of the contract, it's not going to matter. It's just going to be the remainder of the contract at that point. But just be thoughtful about that, as that asking for too much. There's that old saying that pigs get fat and hogs get slaughtered. Well, you don't want to be a hog. Don't get greedy about your compensation and make it likely that you could have a really bad outcome. And then you've also got your indemnity clause, which we'll talk about more in a minute. Now, maybe you decide to retire. You've got your time in. It's time to move on. That's going to be essentially the same as just a resignation. Retirement and resignation end out pretty much the same. The difference usually is under retirement, you would have no severance pay or benefits. However, your board may have a policy that retirees get unused leave, and the board is usually going to want 90 days notice. If you just wait till the end of the contract, then okay, the contract's over. That's fine. But the thing to pay attention to if you're contemplating retirement, I think the most important thing is, what are the implications for me if I retire versus if I resign? Because if you have the opportunity to receive a payout for unused leave if you retire, then you don't want to lose that opportunity. So just pay attention to those provisions if you're contemplating retirement. If you resign, then typically whatever you have under your contract is going to end as of the effective date of the resignation. The standard VSBA contract requires you to give the board 90 days written notice of such resignation. I've seen people change that to 120. I've seen people change that to 6 months. Don't agree to 6 months. That's way too much notice. But realize that the board does need to have time to replace you. And so 90 days is asking for less than 90 days is probably unrealistic because the board has to have time to hire another superintendent. But the language does say the board may, in its sole discretion, waive any or all of this notice requirement. So if you say on let's say you're into May and you just got offered a job at the end of May for another school district starting on July 1st. All right. So it's the middle of May. You want to take this other job, but it's only 6 weeks until that other job would start. So you have to go to your board at that point and say, I know there's a 90-day notice requirement, but would you waive that so that I could leave on July 1? If they waive the notice, you're fine. If they don't, then technically you would have to work it out. Although it's pretty unclear to me what the consequence, the penalty would be if you just left. But nevertheless, you don't want to end badly. And then the other question that might arise is what if this is happening in what if it's happening in January and you're offered a job because the superintendent left somewhere else and you give the 90-day notice requirement that's required and the board says, you're leaving, just leave. But you've already worked it out with the new board that you're not going to start for 90 days. And now your old board, they're kind of ticked off at you because you're leaving and they say, well, we're going to waive the notice and just go and we don't want to pay you anymore. It doesn't work that way. If the board wants to waive the notice and you want to accept that waiver, and maybe it's even in your benefit, that's fine. But if they waive the notice and you want to stay because you've already worked out that deal, they still have to pay you for the notice period because it was an obligation you had to give the notice. They can't just say, well, we're going to waive the notice and waive the compensation you would have received. It doesn't work that way. Disability, I see disability provisions being written many different ways. They're pretty standard these days. It's probably the most variation is what I see. It'll usually say if you're disabled from work for more than some defined period, which it should be at least 60 days in my view, because that's what the FMLA would entitle you to anyway. But you might want to push for as much as 6 months of disability before you're terminated. Then the contract ends. So if the board is going to ask for particularly a shorter period of disability before it terminates, you might ask the board to consider providing a supplemental disability insurance policy that covers 100% of your income, so that if you become disabled and the board is going to terminate you after 60 days, then you have income protection thereafter, covered not by severance pay in this case, but by disability insurance coverage, which is great protection. What happens if you just reach the end of your term? It's just the 4 years are up. The 4-year contract or the shorter term simply runs out. Well, at that point, the board doesn't owe you anything. The contract's over. They've paid you what they promised to pay you. You have done what you promised to do. It's walk away time. However, there is a provision in the code in the VRS section that says if you have 20 years of service credit in the VRS and you've been a superintendent for at least 5 years, then you may be eligible for full VRS retirement. So even if you're in your late 40s or your early 50s, and you can check the boxes that are in the code, a non-renewal of a contract has the same effect under the code as a termination. And so you would be eligible to just retire and get the VRS retirement that you would have gotten if you had gone to the full 30 years and the age plus credit of 80, whatever the current limit is. It would accelerate you to that point. So that's a great protection that's only available to superintendents and other chief executives of agencies like the county administrator or somebody like that. There's just a handful of people across the state that are eligible for that, but it really gives you great protection. And then the standard contract says that each side must give the other side 6 months notice of intent. I often see that rewritten as 12 months. I don't have an opinion about that one way or the other. I guess the more notice, the better, but it's not binding on either party. So it doesn't really have any contractual power. It's just a statement of intent. If either party fails to do it, it's not going to renew the contract. Termination for cause obviously is the thing you most want to avoid. However, it's a high bar to terminate someone for cause in Virginia. It's got to be either for a material breach of the agreement. Now, what's the most likely material breach? It's that you accepted other employment. That would be a material breach of the agreement, and because of that provision in state law. Unless you had worked your agreement to allow you to do it, or you'd gotten the proper permissions. Forfeiture of office, you're just not showing up for work. Immorality, non-compliance with school laws and regulations, willful non-compliance with board policies and regulations, or conviction of a felony or a misdemeanor as set forth in 22.1, 296.1, and that's the barrier crime section. So that's basically your felonies and misdemeanors that would involve abuse of children or something like that. So if you do any of those things, you can be terminated for cause. But that, in my experience, has been extremely unusual. There have only been 2 or 3 terminations for cause, but I have had a couple of situations where superintendents had full severance buyouts in their contracts, and school boards have tried to come up with cause to avoid paying that. So I cautioned against that earlier. I would say this is where that the rubber really hits the road on that concept. If you're in a termination for cause situation, the board has to serve you written charges of what it is that is the cause. You're entitled to a hearing before the board. Now, think about that. The board that just charged you is also hearing you, so you're not going to get a quote fair hearing, but you are entitled to legal representation, and you can appeal to a circuit court. So if you don't get a fair hearing and the board acts arbitrarily or without good cause, then a circuit court can reverse the decision of the board. But if you're terminated for cause, all salary and benefits cease. So you get no severance pay, no health insurance continuation. You don't have any right to leave reimbursement. That all that sick and annual leave that you've been accruing, thinking you're going to get a big check at the end, goes away. But you still have the indemnity provision that protects you. However, if the reason you got terminated violates the indemnity provision, then you lose that protection as well. Indemnity is the concept that the board will hold you harmless from any lawsuits or claims or any legal proceedings that are brought against you. And the thing you have to realize is that if you get involved in litigation, it's not just the fact that you're getting sued for $1 million. It's the fact that defending against that $1 million lawsuit costs a lot of money. And most people don't have that kind of money if they don't have insurance. So indemnity protects you from not just the claim itself, but from the cost of the claim. And it has to be for an incident or activity arising out of and within the scope of your duties as superintendent. So if you're in a car accident on Saturday driving to the grocery store, that's not indemnified. But if you're in a car accident driving to the VAST conference in Roanoke, that is covered by the indemnity. It has to be undertaken in good faith in accordance with the law and within the scope of your official authority. So if you're doing something that's illegal, you're not going to be indemnified against that. And then you want to make sure that you have language in there that talks about insurance protection, and the standard VSBA language does cover that. So as long as your board's using the standard language, all of this stuff's baked in there. But you want to make sure that you have insurance, because the insurance coverage is the best protection you could possibly have. Okay. I have covered a lot of topics, and would be happy to, if anybody has a question you want to ask, you can put it in the Q&A box at the bottom. Right now we don't have any questions that have been asked, but if somebody has a question, put it in the Q&A box and I'd be glad to address it. I see one in the chat box, so let me address that. That one says, might an interim evaluation in December satisfy the evaluation requirement if it's followed up in June with a full evaluation? I would say yes to that. I would say that as long as the board does an evaluation that is reasonably robust in December, whether it's an interim evaluation or not, it's still an evaluation. And then they could follow it up with a more full evaluation. So yes, I think that's a good point. Um, Another question, any feedback related to asking the board to waive the residency requirement, especially after a successful few years of tenure? Yeah, so I didn't address residency, but generally in the standard contracts, you have a term that says that you will reside in the district, you will reside in the city or the county. And that's for political reasons mostly. I mean, it's really embarrassing to a school board if the superintendent, I'll just pick one. Let's say you're in Salem and your kids are going to school in Roanoke. That this the school board is going to be embarrassed by that. They're going to say, the superintendent ought to have his or her kids in my school district, which is, understandable. But there are situations, and I've seen a number of them. I've done exceptions to this, not infrequently, and particularly if it's a new contract, and you're talking about moving your family, and your family is really well situated where they are, and the other district is close by, and you can commute to your new job. You might talk to the board about it. Maybe you have some other reason. Maybe you own a farm, and selling that farm would be very disadvantageous, and you don't want to lose that. Then there are reasons to ask the board to waive the residency requirement, and as long as it's a good reason, then generally that's just fine. How many years must you serve as a superintendent to qualify for full retirement benefits after 20 years of VRS service? You have to be 5 years in your position, and then you qualify. So it's 20 years plus 5 years where you are. Would you recommend having counsel review a current contract prior to seeking renewal of a contract? Yes. I do a lot of contract reviews that are simply because the superintendent is going to go to the board and talk to the board. And maybe if we're going to do a renewal, maybe there's some other things we can tweak. So I think it's really wise to have a contract review before you have any conversations with your board, so that you get everything into one package, basically. Are there provisions that can be added to contracts regarding payment of student loans or contributions to college accounts or 529s? Yes. Quite frankly, you can put anything you want in the contract. There's nothing that is prohibited. It might be from a political perspective. I don't know that putting something in about paying back your kids' student loans, or if they're your student loans to get your doctorate, then yeah, you can tie it to your job. I got the training to do this job. I want you some help repaying that. That would be reasonable, and that'd be a good argument. Paying into a 529 account, I think would be fine. Just understanding the politics of doing that, but certainly it's okay. Another question: if you received a 2-year contract that ends on June 30, 2022, should you begin asking for a contract extension this spring? I would say if you have a 2-year contract, you want to start asking for an extension while you still have a full year left on the contract. So having that conversation in May or June, and particularly if you could get that contract from a June 30, 2022 contract to a June 30, 2025 contract, if that first year is going well and the board will extend it out 4 years, you just added 3 years that you didn't have before. That's terrific. And so absolutely a good idea. Can you ask the board to cover health insurance until age 65? Yes and no, and it's complicated, but let me try to give you as succinct an answer as possible. a board cannot, under Virginia law, make promises that cost money that go more than the legal term. So if you ask the board to cover you to age 65 and the contract runs out when you're 63, then you're not going to have coverage under that contract during that extended period of time. So you've got to be really careful about that.
Craig, there might be one more question in the Q&A from Scott Jeffries.
Is it 5 years in the current superintendent position or 5 years total of superintendent experience in Virginia? I believe it's 5 years in your current position, but I'm not positive about that. I'd have to check, and I can let you know about that. I haven't looked at that recently.
If you have a question that you think of at a later time, please don't hesitate to email Craig or any member of the VAST staff, and we'll forward that to Craig. But Craig, thanks again for doing an excellent presentation. You really help our members immensely, and I know they appreciate it, and the staff certainly does as well. I'll just say it looks like we still have a third of our members in the meeting. We will send everybody the recording of this meeting. So in case there's some points that you'd forgotten, you'll have that. You'll have the PowerPoint as well to refer to. I just have a quick announcement. We're sending this morning, if we haven't done so already, a VAST survey on the VAST blueprint for equity and public education. This is to help us understand where we stand in fulfilling the goals and the objectives in our blueprint. And we know the pandemic has had an impact on our progress. We do have a panel that will be addressing this at our Spring Leadership Series on May 3rd. And we want them to have some information, some feedback from you on what members think our status is in addressing those objectives and goals. So that would be helpful. Thank you in advance, members, for completing that survey. I know it's another survey, and we apologize for all those. But that will conclude the webinar this morning. Again, Craig, we look forward to seeing you hopefully next fall in person at our VAST conference, when you will do another wonderful presentation, I'm sure. So with that, members, thank you for joining us, and we look forward to seeing you during the leadership series starting April 26th.